All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Harvey L. J., Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. As our marshal just told you, my name is Harvey J. I am the presiding judge in this case, and welcome to an oral argument session of the 5th District. That's an important reminder, which I'll talk about a little later. This is a courtroom. We have brought our courtroom from Daytona to Jacksonville University College of Law, and this is a court of law today, which we will be presiding over. I am joined on the panel by Judge Makar, who is my longtime colleague, starting in Tallahassee on the 1st District and more recently on the 5th District. His reputation precedes him in the sense he was a former Solicitor General of the state of Florida, and I believe in that role argued 5 times in front of the big court, the United States Supreme Court. On my left, as many of you know, is Judge Adrian Soud, a longtime circuit judge here in Duval County. He also served in Nassau County, as he has told me very humbly. He served in every division of the circuit court, which is quite an honor, but for a former trial lawyer, and that is I, the most impressive thing about Judge Soud is he presided over almost 200 jury trials. Wow, that's impressive. But we are here today at Jacksonville University, and as I understand it, as you would expect, this is the first time the 5th District has been at the law school. We're honored to be here. We're honored to have Jacksonville University host us. We were at the Arlington campus last year. I happened to be part of that panel. Judge Soud was also part of that panel. So it is our second time at Jacksonville University. First time here at the law school, though, and that matters, and that's a big deal. As to the courtroom, this is a court of law. I know all of you will abide by this, but I will treat it as a courtroom. That means no talking. Please, either turn off your cell phones or silence your cell phones. You don't want to be that person that gets the call during OAs today. I'm certain we're not going to have a problem in that regard. The current plan right now is to take a break after the first oral argument this morning. We will then come back for the last 2 oral arguments. We will do those together. We have also talked to the dean after those last 2 oral arguments have finished. We are happy to stay here on the bench and answer any questions that the students may have of us. Of course, as you well know, that does not include anything about these cases. We are not allowed to speak about that. Please don't be offended by that. But if you were a participant, a lawyer, would you want us to be talking about your case? No, of course not. And it would be unfair to those that may have left our presence for us to discuss the case. So that is the rule as to the Q&A session afterwards. Anything else from the presiding judge? We are ready to call our first case of the day then. And that first case is Caggiano versus Duval County School Board, case number 23-2081. And who is presenting? All right, Mr. Block?
Yes.
You may come to the podium. Have you thought about how much time you would like to reserve for rebuttal?
We would request 8 minutes for rebuttal, Your Honor.
Right now, we have 20 minutes. We have some issues. I mean, every case is important. Every issue is important. We do have some First Amendment issues, obviously, in this case. If it takes a little longer, the court is inclined to give you more time than the allotted 20 minutes. We'll see how it goes. That depends in part on how active the panel is. But Mr. Block, you may proceed.
Good morning. Thank you, and may it please the court. Again, my name is Jason Block, and I have the honor of representing Thomas Caggiano along with my co-counsel, Kelly Mathis. Mr. Caggiano is here in court with us today. I know that the court has already read the briefs and is well aware that we have some serious First Amendment issues, so I welcome and look forward to any questions that the court may have. We live in a time where we are already aware that there are countries like Iran and China and Cuba and Russia where free speech is simply non-existent. But for most of my life, the First Amendment has been sacrosanct in our democracy. But we're finding even today, quite shockingly, that even in democracies like England, where they are threatening people and arresting people for what they say on Facebook, or in Scotland, where a hate crime law has been passed which basically criminalizes speech, or in Canada, which is considering a certain similar legislation right now, or even in Brazil, where an entire social media platform, X, formerly known as Twitter, has been banned.
Well, counsel, let me ask. We're here today on this case. And this case, as I understand it, boils down to 2 Facebook posts by your client, correct?
Correct.
That's all we're talking about. It's 2 Facebook posts. One had to do with Bernie Sanders, joke mode, saying something about wearing a Bernie Sanders t-shirt, getting beat up. That's the one post. And the other one had to do with a repost. Actually, they're both reposts to some extent. A repost of a Waters World graphic showing some hideous statement that Bernie Sanders made years ago. That's this case. That's it. Correct?
That's correct.
That's all we're here about today.
That's correct. And I only bring up that context, Your Honor, to explain what I believe is a trend that's happening, and that is that even in other democracies and now, ominously in our own United States, these things are being threatened.
Now, the context of the post. What year was the post done? 2010 was it?
The posts in this case,
Yeah. What year?
I believe those were in 2020.
I'm sorry, 2020. Right. Okay, 4 years ago.
Yes.
Different presidential campaign at the time.
That's correct. Senator Sanders was not only, of course, a sitting senator, but was a presidential candidate, a leading candidate for one of the parties. And so, to go to where the judge, I believe, is going, these 2 posts go to the core of what is considered First Amendment protection. This is political speech which enjoys and deserves the highest rung of protection under the First Amendment.
Now, was it a private? I mean, there's some evidence that suggests that he thought it was private because his daughter messed up on the settings in some way and accidentally made it public. What does the record tell us? Was this a private forum in which he thought he was in a private Facebook forum, or was it he missed the switch, so to speak, and let it go public?
The record is that as far as he knew, this was private, meaning that only people who had become his friends on Facebook.
That was his subjective understanding.
Correct.
But objectively, was it ever actually public?
We know that at some point in time, whether it was from a hack or because the settings weren't done properly in the first place, or there was a change.
Well, the administrative law judge rejected the hack. He said, I don't find it credible.
Correct.
So that's off the table. You haven't challenged that.
Well, the cause was undetermined under the record, but Your Honor, we submit that it does not matter. The standard is not whether or not the protected political speech could be viewed by others. Indeed, that is what the First Amendment is all about, that all citizens are allowed to articulate their speech and indeed to advocate on behalf of particular political positions. This was not a case, however, let me quickly point out, Your Honor, that he was broadcasting these sentiments or sending these posts to students or to anyone else outside of his circle of friends
Let me
later.
ask you about that, if I may, Mr. Block. It is undisputed, is it not, in this record, based on your client's testimony, that he believed it was private. Now, that was subjective, whether it's reasonable or not, I know Judge Makar made reference to, but based on his subjective understanding, these were private posts to family and friends, correct?
Correct.
Does that matter as part of this analysis? Does that entitle it to a higher level of protection because your client believed it was private?
Well, I think it's certainly a factor under certain cases which could weigh in on whether or not there was an issue with respect to the Pickering balancing. That is, the nature of the speech, the content, the manner, the time, the place. In this case, however, it doesn't matter. And the reason why is we're talking about core political speech, negative speech against one of the leading presidential candidates, again, a sitting United States senator. The fact that it was private just goes to show how far Caggiano went to insulate his own views from his job as a teacher. The fact that ultimately some people made it were very determined to try to uncover whatever he may have said or whatever his views were.
Is it undisputed, Mr. Block, that no students were part of this friend group?
That's correct.
And that is the record we're dealing with, correct?
That's correct.
And no evidence to the contrary.
That is absolutely correct.
Judge Makar also made mention of these were reposts. Is that part of the algorithm, our First Amendment algorithm? Does that matter, that they were reposts as opposed to something that emanated directly from your client?
In the final analysis, it doesn't matter, but it does show that to the extent we're concerned about whether or not Mr. Caggiano was the author of the message, merely sharing something doesn't necessarily import endorsement of it. In this case, he was endorsing those views. He was critical of Bernie Sanders. And with respect to the quote that Senator Sanders made, he was trying to tell his friends and educate them about the fitness of Senator Sanders to be president of the United States. So whether it was a repost or drafted by him, in this case, it doesn't matter. But it does show even further removal from whether or not he generated the post. Same.
If his posts were public, all 7 posts, and he had down Duval County school teacher as he had in his private, so-called private post, would that be actionable by the Duval County School Board to take some action against him for publicly posting those 7?
Absolutely not. And again, just to be clear, none of the posts referenced his job or that he was a teacher or where he worked. It's true that
it could be read to be very intemperate towards women, or some of it was very sexually suggestive, and some references to sexual violence and so forth. Not that he said, but he was reposting. But don't we hold teachers to a little higher standard about, and again, it's hypothetical, if this is public. All those were posted. Didn't the school board maybe have some basis for saying, Mr. Caggiano, knock it off?
I don't believe so, Your Honor, for a variety of reasons. First of all, again, he was not posting as if he were an employee of the school board.
Well, he had his name on there. His name, and he's a Duval County school teacher.
Well,
Right?
his name
Right?
and his
Right.
name, it was on his Facebook homepage.
Right.
It was not on any of the posts.
Well,
So-
right, I know,
But someone would really have to do a lot of digging and want to find out, well, where he
you just
worked.
click on his name, and you go, oh, Duval County school teacher,
Well,
right?
presumably you could. There was no evidence that anyone did other than one person, and they backed into that to discover that, oh, he's the Thomas Caggiano, that he's a teacher. The analysis is whether or not they are speaking on behalf of the government. Pickering on down tells us the mere fact that you are a public employee, including a teacher, in fact, that was the fact in Pickering, does not deprive a citizen of their rights, their First Amendment rights, including to speak out, especially to speak out on political matters. And a presidential candidate who is a sitting United States senator, there is no more quintessential example of First Amendment protected speech than that. Now, the fact that Senator Sanders may have made comments that other people found offensive, Mr. Caggiano found them offensive too, was his exact point. He was telling his friends his colleagues, his family, and ultimately, he had every right to even tell the public and not make this a private setting. Hey, here's a candidate that you ought to know what he said and what he feels about. That is the core of the First Amendment protection. The fact that the school board now tried to hold Mr. Caggiano responsible for merely repeating what the senator had said is the height of absurdity.
And Mr. Glock, is that not a conflation by the ALJ here, attributing the offense to your client when he was offended by Senator Sanders' comments? So the ALJ, though, attributed the offensive speech to your client as opposed to your client being offended by Senator Sanders' offensive speech.
It's Alice in Wonderland. If that were to be the standard, to basically hold that any words are taboo, no matter whether you are the author of them or you are repeating them to condemn them, then really the First Amendment has gone loony. You would not be able to say, if you were a history teacher, to quote Adolf Hitler or George Wallace or any other ignoble figures of politics and otherwise to demonstrate how horrible they were or how evil they were or how they should be condemned, lest the school board, under their articulation of the policy, you be condemned as the actual articulator of that view. That, I would suspect, is anathema to the First Amendment and frankly is insane. And not only that, Your Honor, once the school board articulates this policy, they violate it too. Because in their own order, in their own charging documents, they repeat the same words. So we know that that cannot possibly be a legitimate standard because they are just as guilty in writing it in their brief, writing in their order.
So to understand your argument, Mr. Block, by virtue of the charging document, by virtue of their briefing, repeating those statements, they're guilty of the same thing the ALJ said your client was guilty of.
Absolutely.
That's your argument.
Well, that's to illustrate the absurdity and the hypocrisy of their point.
Well, then they could never bring charges against someone that would post something that's truly hideous. They'd have to, have in camera and put it under seal? I don't understand the argument.
No.
I mean, I think you have better arguments than what you just did there.
Well, again, the fact that they're hypocrites isn't the basis of us saying that, they should be charged too.
There's no law against being a hypocrite, from what I've seen. But what my point is, them putting it into the charging document doesn't seem to me to be anything we need to really talk about.
I agree, Your Honor. My only point in bringing that up is to illustrate how there is a distinction between articulating an offensive view and repeating what some might consider an offensive view for the purposes of calling attention to the offensiveness of
I
it.
see the analogy. I understand that.
Mr. Block, you are in your rebuttal time. You're welcome to use as much time now as you want to, but you're also welcome to sit down.
Okay. I know the court said it had recognized the First Amendment issues. There's other things I'd like to highlight.
Why don't we do this? This is a spirited panel. There are a lot of questions from this panel, potentially. Why don't we add 5 minutes per side? So we would now give him 12 minutes, and same for the Duval County School Board. But please proceed, Mr.
Thank you, Your Honor. So again, the offensiveness of the post itself should not be attributed to Mr. Caggiano. And even if it were, again, it is protected by the First Amendment. In this case, the bizarre fact is that it was not. He was repeating those words to call attention.
Let me ask you on that. As a court, we should do the least amount of damage possible. And what I mean by that is, we can resolve a case on a narrow basis. We should do it. Now, you've asked us to hold some Florida statutes unconstitutional, correct? As being vague. You brought on appeal for the first time the constitutional claims.
Well,
Tell me, what do you want us to do?
okay, the rules that the school board is applying when it comes to speech, we would ask that you hold those to be unconstitutionally overbroad and vague. Those rules, to the extent they're not mere aspirational guidelines, or to the extent the school board is trying to use aspirational guidelines as a basis for discipline, when you apply those rules to conduct as it applies to speech, then yes, we are asking that you hold it overbroad and vague. Now, if Your Honor, if the court is inclined to rule more narrowly, but still on First Amendment grounds, we don't need to get past the Pickering analysis. Now, under the Pickering analysis, the court has recognized, and there's a long line of cases on this, that public employees, including teachers, do not lose their First Amendment rights merely by virtue of their employment. However, the court also recognizes that a governmental agency, a body, needs to be able to operate that agency efficiently and effectively. So it is an analysis of the level of speech, the level of protection the type of speech is entitled to, versus the burden on the department, in this case, the school board.
So you'd be asking us that they didn't meet their burden under Pickering?
Not even close, Your Honor.
And then we wouldn't have to strike something down as being unconstitutional on its face, or we would say it was applied improperly here.
Correct. The court could rule that way. Of course, we've laid out a number of arguments, many of which they didn't respond to at all. But we don't need to go past the Pickering analysis if the court is not inclined to do so. So we've already established that the type of speech involved here is political speech, core political speech, against a presidential candidate. There is no more core example.
So to follow up with Judge Makar's questions, if we were to find that Pickering was applied improperly, what would that mean? Is that game, set, match? Is it over, or do we send it back for more proceedings, or somewhere in between?
Game, set, match, it's over. So the school board has had a full opportunity at a hearing to present its evidence and to make its case. It claims it made its case. It claims it did satisfy Pickering. It has not. Core political speech, highest level protection on this side of the scale. And on this side, let's look at what the disruption is. Now, the school board has dramatically exaggerated the level of disruption that occurred. At most, and I'm going to qualify this in a second, at most what happened was 3 students requested transfers out of Mr. Caggiano's classes. And we know that at Sandalwood High, almost everyone is given a transfer from any class for any reason at all.
But those didn't have to do with posts.
I'm sorry?
The transfers had nothing to do with the post, did they? That was because of an insensitive response given about, I'm not going to recognize your transgender identity.
1 transfer was for that reason alone. 3 additional transfers were for, we're not really sure, but the school board employee testified 3 people requested transfers because of the Facebook posts. Now, importantly, not the 2 that are on appeal, but in general. So the most disruption there could ever be considered at all, granting them everything, is 3 people requested transfers. And again, 90% of the time at this school, transfers are granted for any reason at all. They don't even have to provide a reason. Not only was it not material, substantial, and actual disruption as the case law requires, it was no disruption. The only other argument that they could have for disruption were that 2 parents who did not have students in any of Mr. Caggiano's classroom sent nasty emails. And their complaints were, again, not about the 2 posts that are here on appeal. They were about the transgender issue, for which he was never charged, and about the other posts, that many of which he wasn't charged, were not part of the charging document, or he was found to have been exonerated from the other 5. So even if we grant them all of that disruption, alleged disruption, that falls dramatically short of what would be needed for any kind of discipline, for any kind of speech. But when we're talking about core political speech, the highest, the zenith, that disruption is no disruption. They fail miserably. This court should reverse on that basis alone.
You're in your rebuttal time, Mr. Block.
This is a hot bench. If there's more questions, I'm happy to answer them now, or I can save it for rebuttal. All right, thank you.
Judge, I have 20 seconds to address the
Certainly. Our marshal is adjusting the volume, and as soon as he finishes that, we can start with Mr. Fieser. Good morning.
Good morning. May it please the court, Your Honor. Craig Fieser on behalf of the Duval County School Board.
I think our marshal is still adjusting the volume.
You may want to be closer to the microphone, perhaps.
You usually speak pretty loud.
You ready to start?
Yes, Your Honor.
All right, please proceed.
So I realize, Your Honor, that we're talking a lot about some serious First Amendment issues and a lot of sort of inflammatory accusations that the teacher makes against the school board based on those issues. I just want to step back for a second and sort of remind the court of where we are in the appellate process here. This was a 4-day Department of Administrative Hearings evidentiary hearing, basically a trial, on whether there was just cause to discipline this teacher based on his online, and frankly other conduct as well, but his online social media conduct. There were, of course, the ALJ ultimately said 2 posts warranted some discipline, but the school board had presented evidence on a lot more than just that.
Well, and let me ask you about that, Mr. Fieser, because there is a lot of that in your answer brief. But that seems ancillary to this judge, because I don't see the connexity between any of that and these 2 posts. So am I wrong about that?
Well, just stepping back and just setting aside the transgender issue and some of those other issues that the ALJ said weren't even in the charging document. I'll put those aside. They're not in the charging document. I say that in the brief, that's not really the judge found that was useful background for what the trial was getting at, but it's not why he was charged. But he was charged for, initially they found dozens of posts, but initially he was charged for 7 of them. And some of those 7 posts, besides the 2 we're talking about here, had to do with disparaging comments about transgender students.
Well, that's what I don't understand the posture of the case, because it seemed to me that there was material and also conduct that could be, in the abstract, could be the basis for discipline. If a teacher is basically telling a transgender student in capital letters, I'm not going to refer to you by the name that you have assumed, and there's fallout from that, and there's this transgender, I wouldn't call it phobia, but there's this just intransigence against, recognizing the transgender student's name. When I understand at the time, the policy was if the student wants to be called X, you call them X. So, but this case, it seems to me, has fallen sort of in the cracks because the school board hasn't pursued those claims. And you can't, in a tipsy coachman, go, send it back to the tribunal if they haven't been charged, right?
You are correct, Your Honor.
So today, again, is all about the 2 posts.
Ultimately, that is what the ALJ said. There are 2 posts that warrant some kind of discipline, and of course, he reduced that discipline from what the school board originally wanted. But he did base it on the 2 posts.
There's an old cult film called Bambi Meets Godzilla. I'm not sure if you're familiar with it, but it's kind of reminiscent of, like, gosh, I'm not saying he's Bambi, but sort of this crush of rule violations and it's immoral. And basically, why doesn't the school board just say, look, we're going to counsel you on how to do proper social posting? Leave it at that.
The school board here decided, the school board did do counseling on the incident with the transgender student. That's not considered technical official discipline, it's counseling.
Why wasn't that sufficient?
It was sufficient for that incident. It wasn't, the school board decided it wasn't sufficient here because one thing that you have to remember, it's in the investigative report and it's in the final order, is that when he was interviewed as part of this investigation, he doubled down on what he was going to do. He basically said, I got a right to post anything I want on Facebook. And there is evidence, of course, that a news article came out highlighting a lot of what he was posting on social media.
Some people didn't like it. Some people didn't like it.
And there's not a lot of evidence as far as other people actually transferring from his class, but there is evidence from the principal testifying that a lot of complaints were coming in. A lot of parents were saying,
but for the
not
record,
only am I offended, I don't want my kid in his class.
But for the record, there's nothing in the record that shows he ever used school resources, ever had any communication with any student. He had, how many years was he working for the school board?
20-something.
A long time,
So,
a
yeah.
long time, and that's going to have a clean record.
Yes, and I would agree with that. There isn't. What there is evidence of is that he had a publicly available Facebook account, and whether he knew it was public or not, he didn't check it for 10 years. It had been set up for 10 years.
Let me ask you, if I may, and I'll get into that in a minute, Mr. Fieser, but something you said a minute ago, that he doubled down on his right to post. Doesn't he have the right to post?
He does have the right to his political views, of course. The school board also does, under Pickering and...
I want to interject just a minute.
Yes.
I think you answered a different question. The question was, does he have a right to post? You answered he has a right to his views. That's a very different answer to the question.
And that's correct, Your Honor. If
Does he have a right to post?
He does have a right to post. He does have-
Publicly.
Yes, he does. He has a right to a Facebook account. The school board also has the right to sort of control and regulate what he does with his social media posts. They have a social media policy. And last I checked, most school districts and a lot of public employers have a similar type policy, regulating a little bit what public employees do with their social media accounts. Even if we just talk about the 2 posts that the ALJ found problematic, I'll even go down to the 1 post, the Bernie Sanders post that we've already talked about, what's referred to as the man and woman post. I mean, that is not only vulgar and profane, but I'd argue it's sexually explicit. That's the kind of thing that a teacher
Well,
shouldn't be publicly posting.
if he said that, but he didn't say those words. He basically took a screenshot from a TV show and sent it out and said, yeah, Bernie said this. Like, can you believe Bernie said this? And to convey that thought, he had to use those words. It weren't his words.
Right.
I mean, what if someone posted the Trump interview of you grab women by their private parts? Can you believe he did that? I mean, what's the difference?
And it's fair to say that, if the ALJ was a bridge too far for him to actually attribute that sentiment to Mr. Caggiano, perhaps it was. But he still posted it as a teacher for everyone to see. He should be held to at least a professional standard as far as what he's putting on his
But did he post it as a teacher? He didn't post it in a classroom. He didn't post it on a Duval County School Board website. He posted on a forum that he believed, I know you take exception with that, but he believed to be private. Is that not his right to do, Mr. Feasel?
He has a right to his political views. He has a right to post about his political views, but he also has professional standards of conduct that he needs to uphold. That's what the school board had a problem with, and not, arguably not just on these 2 posts, but on many, many other posts as well that were causing problems within the school. They were getting phone calls. They were getting complaints. They were getting parents saying they didn't want their students in his class anymore. They did have a few students actually transfer from his class. So they made the decision.
Were there any students, based on this record, that transferred from his class based on these 2 posts? Is there any evidence of that?
I don't think there's a direct evidence that these were the exact 2 posts that caused students to transfer. The ones that the ALJ obviously ultimately found were problematic at the end of the day.
Doesn't that go to our disruption analysis? The fact that there's no, again, connection between these 2 posts and someone transferring out of his class?
The disruption, Your Honor, is from the overall online conduct. It's for everything he was posting. It's after the news articles showed up, complaints started showing up, people were able to access his page, parents, students, other teachers accessed his page, read everything he was posting on his page, and there were some vulgar and profane and frankly sexually explicit things he was posting on his page. Whether or not he said them, he was posting them.
But you didn't cross appeal. Did you file any exceptions to the hearing officers?
The school board did not, no.
So they're stuck with, if they really truly believe their argument, they should have filed exceptions with the hearing administrative law judge. Said, Your Honor, you made mistakes. Those other 5 posts, they should be included. They didn't do that, right?
They didn't do that.
Okay.
They didn't do that. And I can't say that they
And there's
did
no
that.
cross appeal.
There is no cross appeal. Which, I mean, without any exceptions, that would be a difficult thing to do anyway if there was a cross appeal. So you're right. We do, at the very least, we have 2 posts. One of which it's just sort of evidence of the kinds of things that he was posting. And he, again, when he was interviewed, he said, I'm going to keep posting whatever I want. I have a First Amendment right on a page that he wasn't monitoring to make sure it wasn't public. Everybody was accessing it, including the media was accessing it.
So in your analysis, the fact that it was public is the violative portion, but if it were private, it would be okay.
If it were private, if it were not able to be accessed by anybody and everybody, that would be a better case for him in our view, for sure. But he needs to be held to at least a standard of what kind of speech he's putting on his.
So let me ask you on that specific point then. Is his speech, let me talk about the statement or the second post which you have described as vulgar, profane, and explicit.
Mm-hmm.
Is his speech the substance of the quote from the Democratic presidential candidate in 2020, or is the substance of his speech the condemnation of the views expressed by the presidential candidate?
As I saw that post, it looked like it was a repost of just that particular quote from the candidate. So I think
Was there not another post commenting, "Wow, can you
He
believe"?
did make a note saying Bernie said this or something like that. But the post, when you look at it on the Facebook page, it's that explicit quote on his Facebook page. And it's an example of many other types of things he was doing at the same time.
I guess anyone watching Waters World would have seen that on the screen. So he's just commenting to something that was actually
It is-
political interest.
It is certainly a repost. It absolutely is. And again, the question is, as a public school teacher, as a public employee, does he have some sort of an obligation or duty to engage in professional conduct? He can politically comment on all kinds of things without getting to that level of sort of gutter comment.
Well, if there was a pattern, if you had 100 posts and they're all sexually explicit or use words that are in here, which I won't repeat, have sexual violence associated with them, that's a different case, right? But this is just these two.
It would certainly be a better Pickering type case if you had dozens and dozens, hundreds of posts, and hundreds of students saying, I don't want to be in this class. But there's plenty of case law that says school districts, public employers have a right to limit, to regulate at least somewhat what their public employees are doing online, posting online.
You said public employers, and I get the school district dichotomy with a teacher, but public employer. I just looked before we got started at all the departments for the city of Jacksonville. Suppose, in this case, hypothetically, Mr. Feaser, he worked for mosquito control, and he makes these posts. These two. Is that violative of some city policy?
It could be. I can tell you as a city employee myself, if I were posting extremely inappropriate things and they were publicly available and people could see them, and I listed myself as a city of Jacksonville employee, I think there could be some sort of, I don't know about discipline, but there could certainly would be a conversation if I was doing that kind of thing, depending on what it was.
You're not drawing a distinction, or you are drawing a distinction to the fact that he was a teacher versus a mosquito control employee.
I think there's a distinction there, sure. I think a teacher should be held to a higher standard, a public school teacher who understood all of these policies that the Duval County School District has to be a teacher for all students all the time, refrain from certain conduct online.
Doesn't, though, the higher standard, as I understand it, and please correct me if I'm wrong, Mr. Feaser, is based on the fact that students may be seeing this. And
they did.
Well, but he didn't think they would. I mean, they are not friends on his Facebook page. He believed it was private. So is that not part of our analysis?
He may have believed that it was private, but it was not private. And he didn't check it, and he didn't make sure that it was. And even once he knew that possibly somebody else was accessing, and he had teachers in Sandalwood that were actually Facebook friends, not students, but he had colleagues that were Facebook friends. And he wasn't doing anything to ensure that the world couldn't see what he was putting on his Facebook page. He just needed to be more professional with his conduct online. And that's a requirement of all teachers. That's what he was cited for. Be careful what you're putting online. There's a social media policy that actually says that from the school district. And he just refused to do that. And when he was asked about it, I'm going to post whatever I want, essentially is what he says. And I have a First Amendment right to post whatever I want. Maybe he can make the page private and nobody will ever see it. Arguably, it's hard in this day and age to make anything really private. You just need to.
So by virtue of that, though, you've shut him down. If you can't make it private, you're saying don't post at all. I mean, is that not what you're
just
saying?
post in a professional way. Be professional about
But
it.
no, back to his posts, though. I mean, you're saying he could never post those because you can't ever ensure privacy. Is that what you're saying?
I mean, arguably, no. I mean, or arguably, he could be potentially subject to some kind of counseling or discipline if he's posting things that violate the social media policy, that are profane or explicit.
Reposting exact quotes from presidential candidates, you're saying is always radioactive.
If it's something like this, it could be, yes, Your Honor. It could certainly be. Because of what it says, what he's posting, and what he's posting as a public school teacher on his Facebook account. Yes, it could be. He can post other things. He can comment about other things. He can engage in behavior that's professional and doesn't violate the standards of professional conduct, any one of which, if you violate them, can be considered by the Florida Administrative Code as misconduct in office. So there is the ability for the school board, and if you look at the investigative report here, and I think it's Exhibit 70 in the ALJ proceedings, in the DOA proceedings, And this was an investigation that was extensive. It wasn't really just about these two posts. I know that's what we're here about because that's what the ALJ found were problematic.
Another question, Mr. Feaser. Suppose these were texts, text to a friend. Prohibited or not?
I don't think text to a friend is social media. Social media. I don't think it's something that's being put out there on the
But
internet.
it's captured. Somebody hacks his phone, his cell account, and it's determined. Is that something he could be disciplined for?
And that's certainly an argument he made, that he was hacked. And maybe if he was hacked, it would be through no fault of his own. It got out publicly. He didn't post it publicly.
So
He put it
are
out there.
texts different?
I think it would be. I think it would be different.
What about an email, private email?
I think it would be different because it's not something he's putting out there. There's a couple of cases that talk about social media. A lot of those cases are more recent, obviously, in the last 20 or so odd years. There's cases that talk about, when you put something on Facebook, you're blasting it out to the world. And there's at least one case, I think it's the Durstein case, where a teacher did post on social media and was commenting about things that you could argue were matters of public concern, critical of Muslims, for example, and was actually fired for that. And you've got a court that says, we can balance that. How much is that kind of, even if it's private speech, she didn't identify herself as a teacher at all on her page. Even if it's technically private speech, is it the kind of thing that the school board is entitled to discipline for and regulate when it's coming from a public school teacher? That's what the school board decided here, was to impose, not fire him, but impose some form of discipline on the teacher for engaging in online content that posed a reasonable threat. It's not just how disruptive they were at the moment, but he said he was going to keep doing this. Is there a reasonable threat there's going to be disruption in the future, more complaints, more parents saying, I don't want my kid in your class? The school board actually made a finding that if that happens, if that keeps happening in the future, we could have other teachers and we could have an equity issue with teachers. Some might have to have more students and then you would have fewer, and that sort of throws off the balance in Sandalwood High School.
Well, tell me, I assumed he served his suspension, had his paid doctor for 3 days, I believe it was 3 consecutive days. And then he's back in the classroom, correct?
I'm not sure what, last I knew he's employed by the school district. I'm not sure what his current status is as far as.
So we don't know today whether he's back teaching math.
I do not know that, Your Honor.
Let me ask you this. Emphasize again, nothing in this record shows that he did anything wrong in his classroom. For example, if he came in with a Trump mug or a Black Lives Matter mug, or you talked about his political views in class, or had a banner up of some political party or candidate. Duval kind of doesn't allow that, do they?
No. Well, and we've had issues with that. I mean, we've had issues with teachers that do things in their classroom.
Bumper stickers on their car in the parking lot?
Teachers have to be careful with what they say that sort of, not just political, but sort of expresses certain views to their students. I mean, they do get in trouble for that, especially in the classroom and directly sort of related to the classroom. I can't argue with a straight face that this was in the classroom or directly pointed at a student or something like that. But it's similar in a way because it's social media and it's blasted out to the world. And it's expressing the kinds of things that can affect a teacher's performance within the classroom, even if it's not in the
But
classroom.
Mr. Feaser, I don't want to beat the proverbial dead horse, but it's not blasted out to the world. I mean, he says that was not my intent to blast it to the world, and I get if he wrote an editorial letter to the paper, completely different paradigm. But that was not this, was it?
Well, I mean, I guess if this court wants to say that as long as his intent wasn't to put it on social media and blast it out to the world, then he's safe, even though he doesn't do anything to make sure that it's not getting out to the world. He knows he's got teachers as Facebook friends. He doesn't even look at his account or the settings in his account for 10 years since it was set up, and doesn't do anything to protect it from being blasted out to the world. And many, many people actually did see it, including the reporter.
Well, and to understand this record, I appreciate it, having read through it. His daughter set this up for him, correct?
I think that's correct.
And she testified that she set it up as private, correct?
Yes.
Again, undisputed in our record?
Thought at the time that it was set up that it was private. It was not. And ultimately, you get 10 years that go by, it's not checked, it's not made sure that it was private, and there's many, many people that are looking at his account, including, like I say, including a reporter. After that happens and news media stories start coming out, we still don't have protection from it being private. We still have other people after that accessing his account, seeing his account.
Well, there's nothing that prevents one of his Sandalwood colleagues from printing out what he's posting and then posting that.
There's not, no.
I mean, like you could print out a copy and then post it elsewhere.
Would that be a violation?
It's the same thing, it could be. It could be if they are posting things in a way that they just shouldn't be putting on the Facebook.
So, Judge,
So that would reach, I'm sorry.
well, I just want to carry to its logical end Judge Makar's example. So a friend says, I'm going to print it out and disseminate it. And you're saying that person would also be in violation of the school board policy?
It's certainly possible. It's
Well,
certainly
it
possible.
depends on what it says. If he did a post that says, I'm going to kill the president, and that someone prints it out, well, that's probably okay. I mean, that's.
I'm talking about this case.
Yeah, well,
Yeah, I mean, so a printout of these posts by another teacher, 2 posts, that would be a violation?
Again, if we're not talking about social media, it's a very, very different situation. You know, here we're kind of talking about what he's putting on social media, which is reaching a lot of people, and a lot of people are seeing it. A teacher printing it out and saying, can you believe this guy said this? I hope they do something with him, or whatever he or she says.
Let
It's
me
a different
carry it
scenario, in
to,
fact.
let me carry that a little further then, and not to get in Judge Sal's way, and we may need to give you some more time, Ms. Feaser, which is just fine, because we'll give Mr. Bach some more time. But suppose, again, Judge Makar's very good hypothetical, print off his Facebook page, and then makes copies for the faculty lounge. And everyone, the whole faculty of Sandalwood has a copy of that. Is that a violation of the school board policy?
Again, it could be, Your Honor. It's not social media. It's not the same thing that we have here, but, you know, I don't know how far publicly disseminated would go, but that, to me, that doesn't sound like it's publicly disseminated. It sounds like it's still between the teachers. It doesn't cause the kind of professional conduct violations, threat of disruption, that putting something on social media where students and parents and others can see it, potentially disrupting school operations or efficient operations in school, it doesn't seem like that would rise to that level. And it's just a different thing than social media.
Judge Sal?
I'm fine.
I may have covered it.
So, so ultimately, our position is, I understand that this is a First Amendment case. It's the first time that they've raised First Amendment issues on the appeal, as is appropriate.
But they had to make the record below. In other words,
That's correct.
just so that we have an understanding, the ALJ had no authority to make a constitutional adjudication.
Yes.
But they had the obligation to create the record to form the basis for any action we might take on a constitutional claim that they've raised.
I think that's absolutely true, Your Honor. And they have to do that. There's references to it from them in the record below, that you can't do this under the First Amendment, even though the ALJ is not able to decide whether any discipline at all, based on what happened here, would violate the First Amendment. And he didn't make that decision.
Is it a purely discretionary, unreviewable decision by the school board to say, well, we could just give him some informal counseling, but we're going to go and suspend him or terminate him? I mean, is there anything under the statutes, the rules, the labor agreement that says you can't just go from home plate and just...
There is references in the collective bargaining agreement that you can sort of elevate the progressive discipline to what it is here, which was ultimately a 3-day suspension and a reprimand and a culture diversity course. So there is references in the CBA that if the school board finds that this kind of conduct is egregious enough, that they can escalate
But
it.
that's not, the escalation is not reviewable, meaning no tribunal, judicial tribunal reviews that.
I believe that's probably more of a civil service board type issue or something like that as far as whether progressive discipline is properly followed. I don't know if like a First Amendment claim could potentially be made based on that kind of an escalation. They didn't choose to fire him here. They didn't choose to go the ultimate route. They chose to, give him a warning, give him a suspension, a couple of days suspension, and make sure that he understands that you need to be careful with what you do on social media. You need to be careful with what you're posting on social media. And that's essentially what they did here.
And he's completed everything.
I'm not even sure if he's ever served a suspension because his case has been basically appealed all the way through and sort of everything's kind of stopped. So I don't know if the discipline's ever really actually been imposed on him. But I understand it's a First Amendment case, but what we have here is whether there's just cause on this record to impose any type of discipline based on this investigation of what he was doing online. And our position is that he is subject to some discipline and has been subject to some discipline.
We can't send it back and say, oh, the sensitivity course was enough.
this court could do whatever this court wanted to do and say, that the discipline is too harsh or too much. But at the end of the day, we would ask that the court affirm what the ALJ did and what the final order says.
Mr. Fieser, this is somewhat unique for this judge. If you would like another couple of minutes, I will give you 2 more minutes, but if you're finished with your argument, we'll move on to Mr. Block.
I think the only other point that I'd like to make, Your Honor, is that
We'll give him 2 more minutes. Right?
is that I understand the argument that this is political speech and that this is a particular viewpoint of political speech that this particular teacher is conveying online. In my view, there's nothing in the record that shows that this discipline was imposed because of that viewpoint. This could have been any kind of profane or vulgar or inappropriate or disparaging speech, no matter what your political view is, no matter what you believe about X, Y, or Z, either side.
It was free speech, not political speech.
It's a free speech case, not a political speech case. That's exactly right, Your Honor. That would be my position.
But doesn't it go to the content, Mr. Fieser?
I don't think it does go to the content at all. I think it goes to the inappropriateness of the speech itself, what he's posting online. There could be all kinds of different content of speech that could cause disruption, and court says that you can regulate content to some degree to prevent against that.
But would that argument require us then to divorce the speech from the context? And how are we to do that if it does? In other words, free speech versus political speech, whatever speech occurred at whatever stage, it's in the context of a political dynamic or consideration at a time when a presidential primary is being held, was it not?
It's certainly in that context.
So help me, and I say this in all sincerity, help me understand how we pull that out of that context and draw that distinction.
The distinction is, what does the speech say? Is it the type of speech that violates the social media policy, which says, don't post in a vulgar or profane or sexually explicit way. It doesn't matter that it was during a presidential election, also right in smack dab in the middle of the beginning of the COVID pandemic as well. I would also point out, which was a particularly, as everyone knows, a particularly difficult time for schools and for students. So there is context here, but it's really what he posted that matters most, not when it was posted or what it was about. And so that's why I would argue it's not a content-based restriction. See, I'm about done with my time, so I thank you very much for your time, and we would ask that you would affirm the ALJ's or the Duval County School Board's final order.
Thank you, Mr. Fieser. We will add 2 additional minutes to Mr. Block's time.
Yes, sir.
Based on what I just gave Mr. Fieser. We want to be fair to both sides. Mr. Block?
Thank you, Your Honor. I just want to address one thing right off. Mr. Fieser mentioned that this was not a content or viewpoint based ruling, and there's nothing in the record that says that. I'd like to draw your attention to the actual order, which says, this is on page 578 and page 584 of the record, the 2 posts at issue concern violence and abuse of a child, as well as discriminatory and degrading views of women being abused and raped. That is a content-based description. The abuse of women and children, that is content-based. And anytime there is a content-based prohibition on speech or limitation on speech, then we immediately go to strict scrutiny. Courts hold that content-based restrictions are presumptively invalid. And then it becomes the burden of the government to prove why there is there's a compelling government interest and that it is narrowly tailored. They've done neither. But they go even further because there's also a viewpoint-based description or restriction. And we know from the case law that viewpoint-based restrictions are per se invalid. Those can never be affirmed or allowed to stand. And we've cited cases that say that when you talk about discriminatory views, that is a viewpoint-based restriction. The rule that is articulated by the ALJ and then adopted by the school board in the order is explicitly both a content and viewpoint-based restriction on speech.
I think to follow up on Mr. Fieser's point, if you look at the post overall, it isn't all about Bernie Sanders. There's the use of the word penis, dumbass liberals, the M-word, so to speak, Democrats, nasty bitch. I mean, is that really, that's what the school board, I think, was concerned about, was the overall use of this inflammatory language, some of which was reposted, and some of which was his own words. So,
Okay, so let's be clear. Again, I think as this panel understands.
that wasn't what I just, those words and phrases, which I hate to have to use, they're not about politics. They may have been in a political context. But I think his point, and it may be valid, maybe invalid, is that's what we're worried about, is these types of phrases and words being used by teachers.
Okay, well, again, just to remind everybody where we are at, that language that you're referring to may have been part of posts that he was not charged with?
No, he was charged. It was all, it's right here. It's in the charging document.
Okay,
But it was the ALJ, not the Duval County School Board, that honed it down to just the 2 Bernie Sanders posts. It wasn't like the school board said, we're upset because he's doing a political speech about Bernie Sanders. No, it was a whole litany of things, some political, some not. And they're just worried. This is, I'm trying to make the point I think he was trying to make, which is that has nothing to do with politics. It has to do with appropriate use of language by a school teacher.
Okay, some of those were reposted language, some of it may have been his language. But we have to remember that of those 5 posts, the ALJ concluded that all 5 of those were protected political speech. This is conceded by the school board in their answer brief. This finding is embraced by the school board itself when they adopted this order in full. There were no exceptions. There is no cross appeal. So that issue is already resolved, and I could get into trying to defend why those are also constitutionally infirm and to support the ALJ's ruling and the school board's, but that is not what's on appeal. All we have left are the 2 posts, which is what Your Honor opened up with at the beginning. That's what we're talking about now. Now, I was merely responding to my friend's position that there's nothing in the record that this is a content or viewpoint-based restriction. It is explicitly that. Now, if I'd like to get back some of the other things he said. Your Honors asked him hypotheticals about other forms of communication. Well, does it make a difference if it's on social media or not? My friend says it does. It does not. We cited the Livermore case, which basically says, in today's day and age, Facebook is just the equivalent of writing a letter to the editor, as was protected in Pickering. The fact that it's on social media does not diminish in any degree at all the constitutional protection under the First Amendment that communication involves. We cite the ACLU case that says you can't, as a government, say, hey, don't worry, we're restricting you from this medium because you have another medium. Again, that is not permissible. Facebook is the way that modern people, in many ways, and other social media communicate. Now, my friend also talks about the social media policy. For the first time, I think I heard them say, either in their brief or here, that it violated by talking about vulgar language. I don't recall any of that discussion in the brief whatsoever. But they never identify how there's a violation of the social media policy. There were no findings of that by the ALJ or in the order. Now let's go through some of the illustrations that Your Honors put out. Let's suppose instead of a Facebook post, it was a lawn sign that said, "Can you believe Bernie Sanders said this?" and put up that quote. According to my friend, would that be prohibited? It's on his lawn. Anybody could conceivably come up and see it. Let's say it was a private email or a text message intended to be private. Well, we know that those can be further disseminated and then ultimately uncovered. In the recent Supreme Court case, in BL, the cheerleader case, the cheerleader articulated her views on Snapchat. Those expired within 24 hours, but they were captured and reposted. The Supreme Court said the fact that they went through that medium does not diminish their public protection. Anytime there's communication, whether I say it to somebody, a friend at a restaurant, and it's overheard, or it's on a bumper sticker that I drive around car, or I have a lawn sign, or any other form of medium, that can always be repeated and reheard by somebody else. That does not diminish its protection, and specifically, contrary to my friend's argument, that protection is not diminished one iota by the fact that in this case the speaker is a public employee or a teacher. He simply asserts...
Well, that can't be the principle. The principle can't be that it's unlimited what you can say in post.
Correct.
And that's what I'm hearing you saying. That's just not the law.
I agree with Your Honor, and I am not saying that. What I am saying is that a public employee, including a teacher, has the same rights of First Amendment protection as any other citizen, modified by the Pickering analysis, which is
Given the position they're in.
given the position they're in.
Right.
And then the burden shifts to the school board to say, well, whatever it was, political speech, less than political speech, but social advocacy, you have to measure the level of protection of that speech. And we know that this is at the highest rung, and I think my friend concedes that, against the disruption that the agency endures. And we've already talked about the disruption. You'll find in this order, there are no findings of any disruption
I said there
whatsoever.
was disruption because they had to get another teacher to come into the classroom. Has your client returned to the classroom?
He has not, Your Honor.
Is there a reason why, or?
The school board kept him furloughed at a warehouse, and he has not been allowed to return.
Is that part of what you're asking us to give relief on, or what do you want us to do?
We would like the order reversed in its entirely.
We can't order him put back into the position.
What my understanding is that
He's recently retired.
he's recently retired. He has essentially had enough. He has not used Facebook at all since these things happened. And so we would ask for a reversal so that he can have his pay and his record restored. But I think this is very important, Your Honors, is that the school board and the public need to understand how the First Amendment works. And I would like to talk a little bit about the chilling effect of this. Just as Your Honors were giving my friend hypotheticals, well, would this violate the policy? Would that violate the policy? Well, yeah, maybe it would. If you're a school teacher or any other public employee that knows about what's happened here, you are only the most courageous, financially stable person is going to be able and willing to take on this challenge. Because after this came out, what teacher would dare post or discuss any political opinion? And the examples that they give, again, quoting Bernie Sanders, which many people find that quote offensive. Well, what if a teacher wants to say, you know what? I support Bernie Sanders. I think he's great. What's to stop someone else from coming in and said, do you know what Bernie Sanders said? He said these offensive things. And I don't want to be in a class with a teacher who supports Bernie Sanders because of his views about women, or virtually any political opinion at all.
Mr. Block, we have gone past your allotted time. I'll give you another 30 seconds to give us a summation.
Thank you, Your Honors. We've given you ample grounds to reverse. We've told you how this policy is overbroad and vague. We've told you how it's a content and viewpoint-based restriction. We discussed that extensively in our briefs. School board does not really address those matters at all. If the court is inclined to go narrow, you don't need to, but if you can, the Pickering analysis is very simple. Highest level of protection, almost no disruption at all. Certainly none that they could point to that relates to the only two posts that are on appeal. We even, and I'll wrap up with this, pointed out, even under the policies putting the First Amendment issues aside, each of the alleged violations were not supported and could not be supported, or were aspirational guidelines that could not be penalized. No response from the school board at all. This is an important case. We thank you for your attention. We urge you to reverse and protect the First Amendment rights, Mr. Caggiano and all public employees.
Thank you, Mr. Bosch. Thank you, Mr. Fieser. Well presented on both sides. It was very much a hot panel, which may be an understatement. Why don't we take 15 minutes? We'll take a 15-minute break. If this clock is correct, and I assume it is, it's very close to being correct. Why don't we plan to come back at 11:20? At 11:20, we will resume with the other two oral arguments, one after another. And after that, as I may have mentioned in the beginning, if the students want to stay after that last oral argument, we'll be here to answer questions. But we'll be in recess for about 15 minutes.
All rise.